afternoon, ladies and gentlemen, and welcome to this session. We're waiting for one speaker, so I will start with some minor matters. Here's our speaker. I'll start with some minor matters. First of all, we need to thank our sponsors, the Golden Partners, Visa, Freedom Holding Corporation, and ITS. I also have to warn you that we may have a fire alarm. If that happens, we have to get out into that atrium by going out and to the right and back again, but it won't happen. This session is dedicated to the issues of the practical application of the AIFC jurisdiction, including aspects of doing business in the AIFC, providing legal consulting services on corporate structuring, dispute resolution, and commercial transaction. And the order of speakers, I will present them to you. They go this way in order. Andrew Oldland is the first substantive speaker, member of the Legal Advisory Council of the AIFC and a partner at Mitchell Moores. He'll be followed by Maxim Burak, a partner at Grata International Law Firm. He will be followed by Kuanish Shekerbekov, Managing Director of Kin Stellar Limited Liability Partnership. Then fourth, Simon Cox, Chairman of the AIFC Legal Services Board and Senior Consultant at Norton Rose Fulbright in London. And lastly, but not least, Christopher Campbell-Holt, the Registrar and Chief Executive of the AIFC Court and International Arbitration Centre. So without more ado, may I ask Andrew to take us to the first speaker.
Thank you, Michael. I will try and be as brief as I possibly can because of the eminent panel of co-speakers here. The topic I'm going to speak about is why the English common law model was chosen for the legal system within the AIFC. To do that, I'm just going to show you a few charts as to where things fit in. The constitutional statute, which is outlined in red on that slide, is the piece of legislation that created the AIFC and provided for various matters. And within those were clauses relating to the operation of the common law. And it's Article 4, AIFC acts which are not inconsistent with this constitutional statute and which may be based on the principles, legislations, and precedents of the law of England and Wales and the standards of leading global financial centres. So there's a clear steer in the enacting legislation towards the English common law. Also within the constitutional statute are important articles in relation to the operation of the court, where at 13.5 and 13.6 the court, which may take into account final judgments of the court and of courts in other common law jurisdictions. There's also a steer towards achieving international best practice, as you would expect. It does not cover criminal or administrative law. And other than that, it's the acting law of the ROK that applies where it's not governed by the statute or AIFC acts. So the default position is the law of Kazakhstan, which creates occasionally some quite interesting tensions in the operation of the AIFC. But what is a common law system, first of all? And I do apologise to those of you who know it backwards, but it does bear repeating. It's based on the concept of judicial precedent. Judges take an active role in shaping the law, since the decisions a court makes are then used as a precedent for future cases. And a key doctrine is binding precedent. In other words, courts must follow what more senior courts have previously decided. So common law systems have laws, obviously, that are created by legislators, but it's up to the judges to rely on the precedents set by previous courts, subject to the hierarchy of the courts, to interpret those laws and apply them to individual cases. A common law system uniquely can create its own substantive law. For example, in the UK, the offence of murder is an offence contrary to the common law. It's not a statutory offence. It can create procedural rules that enable the proper operation of the courts and also allow for remedies, in particular equitable remedies, the solutions that you seek where there's a dispute, and the flexibility of the court in occasionally filling in the gaps left by statute. But Parliament is sovereign and can pass legislation which supersedes or replaces common law rules if Parliament does not like the way the courts are going. So why choose the English common law? 2 words: familiarity and flexibility. The law underlying international trade, although partly codified, has material common law input. Common law regimes contain concepts of value for commercial parties, such as trust law, fiduciary obligations, restitution, and a streamlined and flexible set of insolvency regimes. And as you know, English common law is widely used in international commercial contracts and in the financial world, where it's recognised to be both familiar and flexible. And it can evolve as necessary rapidly to meet advances in technology, which is why I would argue it's particularly well placed to deal with the legal issues that are being thrown up by advances in technology that we see today. Successful legal systems have to be predictable, fair, clear, stable, but also able to govern the activities and relationships of business. So English common law meets these requirements and is widely respected and utilised across the world. I should say that before the likes of Michael, myself and other lawyers ever became involved in the AIFC, a decision had been made to choose an English common law system. So it wasn't down to us, those who practice the English common law. It was down to independent people assessing which was the best system to apply. But an independent judiciary, we've heard a good deal about that today, is at the heart of any successful common law system, not only resolving disputes, but also creating a body of legal precedent which governs commercial relationships in a fair and effective manner. And the AIFC legal regime ultimately is a simplified, codified version of English law, which we call the general legal framework, but it is also subject to common law principles. So you've got a code and you've got common law principles that apply as well with it. And that is the legislative hierarchy again, and you see that through the decision-making process, towards the bottom, you've got the general legal framework regulations on the right-hand side, and on the left, the financial services framework regulations. So a body of law is the GLF, which underpins the operations of the financial centre. There they are. I'm not going to spend time on that. It's not an exhaustive list. Those are the pieces of legislation that have been introduced to operate as the general legal framework. You'll see and recognise many of them. And there is also the regulatory regime, which is underpinned by the GLF. And at its core is the central financial services framework regulations, which permit the regulator, AFSA, to introduce its own rules. And both the FSFR and AFSA rulebook are based on 2 things. 1, international best practice, and 2, the particular needs of the financial centre. And that is a synopsis, again not exhaustive, of how the rulebooks work. At the centre you've got the regulation. Feeding out from it are the various rules that have been introduced by AFSA. So that is my brief analysis as to why the English common law was selected and its advantages. So I'll hand over.
Yes, please.
Yeah.
Thank you very much indeed, Andrew. May we pass the baton to Maxime Bourac, who will be speaking about practical insights of mergers and acquisitions and structuring of holding companies. Thank you very much, Maxime.
Thank you. Thank you very much for this. We've been preparing this material with my colleague, Mr. Rajan Aymak. My name is Maxim Burak. I'm head of corporate practice here in Astana at Garata. And Mr. Rajan Aymak works with me as a co-head of this practice. Based on our 5 years experience in AIFC law and particularly in M&A structuring, in joint venture structuring, I would say there are a number of practical implications and practical insights I'd like to share with you. So I will give this speech, this example, based on, say, hypothetical M&A transaction of a private company as a most widespread legal form in AIFC. So as you can see, the structure for a transaction looks pretty straightforward. It consists of, say, 4 steps. And I would put some practical, maybe, insights we've had during our practice to show how it works and to demonstrate that it actually works and it works well. So first of all, if we go through the steps of an hypothetical M&A, we regularly advise to consider the variety of possibilities provided by AIFC law in terms of structuring such kind of transaction. Usually it is, first it's either charter capital contribution, share capital contribution, or a direct sale. Obviously, it depends on where you want the money to go. And in terms of this contribution scheme, AIFC law provides a wide range of options to proceed due to the possibility to issue different classes of shares with different rights, with the possibility to make them entitled to dividends, to voting rights, or vice versa. And it gives lots of flexibility even in terms of distinguishing the management of different types of businesses within one holding company. We had an experience where we structured such kind of businesses. A client of ours, they had 2 different types of businesses, but they wanted to have this governed by a single company, and they wanted to govern this at that level without any additional division. So we did so, and it works. It works like you can basically split the voting rights and manage this very precisely. And obviously, it always requires to do some careful analysis in terms of potential approvals to be triggered, because some transactions may trigger anti-monopoly or some other approvals regular for Kazakhstan. But in addition, if you go into a market regulatory services company in AIFC or market services, you may need additional approval from the AIFC as well, depending on the threshold. And this approval requires gives some qualification requirements for the investor to come. And other, I would say, regular steps for a structuring, like tax structuring, it is not so relevant for an AIFC company, given the tax exemptions provided here. However, if you structure it on some level above or below, this also may become an issue. And I would also pay high attention to the particular UBOs you'd like to introduce in the company, because these days, given the whole global political situation, AIFC pays lots of attention in terms of complying with the legislative restrictions imposed by various governments throughout the world. And you may wish to put it carefully, especially if you establish a new joint venture instead of making an M&A. And as my colleague Anish, I guess, will enlighten us a bit further, there is also a possibility to move an existing regular Kazakhstani company into the AIFC. This is quite new, but this is very unexpected and I would say interesting possibility for M&As in AIFC. As to the due diligence, given the tight time frames we have, I'm not going to go very deep on this. I would just say that given this lack of well-established practice in AIFC yet, because 5 years from the very beginning, it is not too much, I would pay high attention to a due diligence of an AIFC company, especially to financial audit, because nowadays it is not very clear how the tax authorities are going to check an AIFC company in the future, because AIFC companies must follow IFRS, but how it will be done and how we can match all the possibilities provided by AIFC law in terms of corporate governance, in terms of charter capital contributions, say share premium possibility. It is not clear how they will consider this when a full-scale tax inspection is conducted. Then the next stage is obviously transaction documents. In this aspect, we regularly advise our clients to pay high attention to AIFC court as this very good possibility to have, I would say, arbitration level judgment in terms of its qualification, directly enforceable in Kazakhstan without the necessity of having any additional steps. This is extremely useful possibility. We advise everyone to follow. And also there is a number of possibilities which is not regular for regular Kazakhstan jurisdiction about converting a debt into share capital contribution. This is also an extremely useful thing, especially when you're speaking about an M&A of a holding with shareholder loans which need to be set off, etc. In Kazakhstan, this may become a problem. Here, it can be dealt with pretty smoothly. The next slide is about these shareholders, like corporate documents for this future company of yours, for this future JV. I would inspire you to enjoy all the possibilities of AIFC law provided for corporate governance in AIFC, because it as opposed to regular Kazakhstan jurisdiction, I find it exciting, because it provides all these regular things like tag-along, drag-along rights, put call options without any extra steps and turnarounds which are maybe usually necessary for that. But there is also a quite tricky thing in this respect. Is about this applicable law problem, which I believe some of you may be familiar with. It's about that rule in Kazakhstani civil code that shareholders agreement with respect to a company incorporated in Kazakhstan, and AIFC companies are still considered as incorporated in Kazakhstan, must be governed by Kazakh law without any qualifications. And this, I believe, may require some attention in the future from our parliament, because this looks like an omission, at least to me.
Maxime, could I ask you to move to your final remarks, if that's in order?
Sure.
Thank you very much.
Yeah. So basically, this is almost it. After fulfilling the conditions precedent, which is pretty obvious stage, you go to the transaction implementation. And that stage usually involves the same steps which you have in regular Kazakhstan jurisdiction. 2 points to mention is that you need to notify the AIFC about this transaction happened, about this fact, and you need to get yourself this shareholders register in the company, because to the contrary, from regular Kazakhstan jurisdiction, it is not the state who holds this register. It is you who must hold it. So that's it. And, yeah, thank you.
Thank you very much indeed, and I'm sorry if I cut you short.
No, that's fine. Thank you.
May we move on to Kuanishek Bekov, who will be speaking to us about transfer of incorporation and redomiciliation. Thank you very much indeed.
Good afternoon, dear friends, dear colleagues, guests of our panel discussion. As Maxime has mentioned, there are traditional ways how investors can incorporate their business and presence in Kazakhstan, and he mentioned that one of the alternative ways to do so is setting up business by way of so-called redomiciliation process. So in my part, I like to talk about this way. So in short, redomicile is process, as I said, alternative process how investors can move their business into AIFC, and this is done by way of moving current legal entity, which it has in foreign jurisdiction, and it just moves it to AIFC jurisdiction. From legal perspectives, it doesn't result in liquidation of current existing legal entity. It just results basically in change of its home jurisdiction and physical address, but otherwise company which, for instance, exists in, let's say, BVI or Bermuda, it will continue its life in AIFC. So I guess it's something which maybe Kazakhstan lawyers may not be aware of, because this mechanism of establishing business more familiar for common law jurisdictions, and it's something which exists there, but not in countries with continental legal system. So this is, in this respect, it's so unique for Kazakhstan, and I can say that it's also unique for CIS region, including for Central Asia. So AIFC legal platform provides this opportunity for foreign investors to consider this option in case if they, for commercial reasons, don't want to create new legal entity in Kazakhstan, or if they don't want to purchase new company or existing company in Kazakhstan, and as an alternative, they may want to consider this option, migrating its current company to AIFC. It's very convenient because, as I said, it doesn't result in liquidation, so it's not like shutting down the company. Company preserves and maintains its current scope of assets, rights, commitments, obligations. So in simple words, company continues living, just it changes its home address and jurisdiction. This type of, this scenario may be of interest for investors in cases where, for instance, home jurisdiction changes its tax regime, or maybe it has certain new requirements which make hard and difficult for companies to exist in its initial place of incorporation, and in those circumstances they may move to another country, another jurisdictions, in our case AIFC. As I said, tax matter, I guess it's, I think, the most, the factor which drives this process. Then commercial reasons why parties would want to change their home jurisdiction. And also generally, as you know, with the world moving into a more transparent world, we all know that nowadays companies need to disclose their UBOs, and tax regimes becoming more transparent. So the traditional offshore zones where usually investors hold their holding companies may not be attractive. For instance, in lending process, banks may not want to give loan if they see that parent company sits in one of those tax haven blacklisted jurisdictions, and they would want to see more transparent jurisdiction. And AIFC is one of such transparent and clean jurisdictions, which may be very attractive for investors. And redomicile is something which should be in the list of points for investors to consider. And we, as a firm, we have done the first redomicile project in AIFC. We moved Bermuda Incorporated Company into the AIFC a few years ago. So we've been pioneers in this area. And so basically we have practiced, we have tested this path. It works. And if we come down to process itself, obviously there is certain procedure, there is certain process that have to be followed, and there are certain documents, obviously, that needs to be submitted to AIFC. I will not stop on this in detail, but overall I can say that the process is not prescriptive. It's relatively straightforward because it doesn't result in liquidation. So, and in timeline, in time-wise, it's also, I would say, of course, it would depend on the type of activity, but in general, we are talking about 2 or 4 months, and I think it's adequate time, given that there are 2 countries involved in this process, so basically home jurisdiction and AIFC. So if we talk about practical aspects, yeah, I think the first thing which investors should check whether their home jurisdiction allows this process. So it starts with this. So basically, if their country's laws permit redomicile, also in some jurisdictions, it's called continuation or discontinuation. So if it allows, then you are welcome to AIFC. And which is good, AIFC also allows back process. So if in the future something goes wrong or investors want to return to their home jurisdiction, they can do so anytime. So it's mutual process. You can move to AIFC, and then you can also leave AIFC to your initial jurisdiction. Also, another point that investors should check always is to analyze current scope of jurisdiction, whether what they're doing now in their home country requires any licenses within AIFC. And if that's the case, then yeah, that may have certain impacts on the timeline, because there's some additional steps that needs to be done in AIFC, but in general, it's possible. And also for investors, it would be always prudent to do their homework, to just compare legal regime in their country and in AIFC, just so that they're comfortable, because basically they're moving to another country, another jurisdiction with its own laws. But as my colleague said, AIFC platform is great because its legal regime and environment is very similar to common law jurisdictions. And when our client, as I said, KERK, Kazakhstan energy insurance company, which we moved here, they lived for many years in Bermuda, and when they moved here, they basically haven't noticed any differences in terms of corporate culture and environment, so it's almost the same. As I said, when company moves to AIFC, it keeps all its assets, rights, and even court cases to which it is a party. And when it comes here to AIFC, it can also keep its current share capital, so it doesn't have to top up its capital here. So if we're talking about holding companies, they can just move with the same share capital to AIFC. So there's no financial...
Can we move to your final conclusions?
Yeah.
I think you're very nearly at the end.
Concluding remarks, just I want to emphasize that this road, redomicile, doesn't result in liquidation, first of all. It's the same company, which is good for lenders, for creditors, and most importantly, from tax perspectives, it doesn't result in capital gain for shareholders who move their companies to AIFC, because ownership doesn't change. So, And just one more thing, we've been receiving enormous interest in this road from investors, and we are now working on several other projects which we hope to complete soon. And yeah, as I said, we've done the first redomicile project in Kazakhstan in AIFC, and as legal advisors, we can say that this road works in reality, in practice, and we have established path. So, yeah, thank you.
Thank you very much. That's a good way to end. Yeah. May we move straight on to Simon Cox, who is going to talk to us about professional regulation. The right man to do it because he's the chairman of the AIFC Legal Services Board, as well as being a consultant in London. Thank you, Simon.
Thank you, Michael. I think as you say, the hat I'm wearing, and I wear a number, the hat I'm wearing in this context is, I think, chairman of the Legal Services Board, which is involved with the regulation and supervision of individual lawyers practicing in the AIFC. A number of distinguished members of both on this stage and in the audience are members of the panel, and I'm rather wary about speaking in their presence. But I think the progression of speakers along the floor has really shown what this is about and the context in which we're looking at legal services regulation. As Andrew so eloquently set out, this was the creation of a legal structure completely different and independent from the, if you like, the host legal structure. And coming along the panel, we've had examples of specific implementation of AIFC law and how it works and how it can be utilized to serve the needs of all our clients and to help achieve the objectives of creating investment into Kazakhstan, supporting it, providing liquidity and other cash flow mechanisms for domestic businesses, investment funds, all these other things. And there's also addressed in a panel this morning, but it's a living, breathing structure. And what is absolutely fundamental is that there is a build-up of expertise of people who can advise on this, because it's no good having a perfect rule book, and it's not that at this point, but it needs people who can apply it and have the experience and skill to do that, and I'm going to come back to that in a second. But ahead of going rather rapidly through the structures involved in this, I want to address up front an issue which came up at one of the sessions this morning. I wasn't there because I was standing on my hind legs, as it were, somewhere else. But the question was, what sort of imprimatur, what sort of quality mark is attached to someone being a registered legal advisor? The answer at the moment, and I'll come back to what the qualifications are, is it is a relatively low hurdle. It does not deal with the quality of individual lawyers. I'll come back to what people need in order to be able to register at the moment. But it is the build-up of expertise and the recognition and acceptance by clients of capability which will be the basic hallmark and quality mark of what people are. And what we're not saying is that by approving someone for registration, we are saying they are a fantastic lawyer. We hope they are, they probably are, but we're not guaranteeing that. The structure, it's on the screen at the moment, the target is international best professional practices. There are codes of conduct for lawyers, individual lawyers. There's a designated body, which is the Legal Services Board, and there's legal education at the Academy of Law, and I'm going to come back to these briefly in a moment. The key players are AFSA, which regulates legal entities which are providing law services in or from the AIFC, and that's not what I'm talking about now. And there's us, the Legal Services Board, who are responsible for the registration and regulation of individual legal advisors. And there's the Academy of Law, which provides training to bring people up to a required standard. The AIFC Legal Services Board, we have a rule-making function, a regulatory function, a registration function, disciplinary enforcement powers, which happily we've not had to use, and one or two other functions associated with the development of legal services at the AIFC. I'm not talking about rights of audience. Chris is going to come on to that, and I think we're looking with awe and wonder at the fantastic achievement which Chris and his colleagues have achieved in terms of the build-up of the court and the IAFC. But purely from the context of the registration of individual lawyers and law firms, 55 entities approximately have been authorized by AFSA as legal service providers, or currently authorized, and approximately 150 individuals, with 14 new ones yesterday. If you're among them, congratulations, being registered as registered legal advisors. We see the benefit of people being legal advisors. They are operating the global financial center under best international standards of legal services regulation and indeed of the conduct of business. It's a diverse, business-friendly environment. We can see how many nations are represented in this room, let alone in this center. Over these 2 days, more than 1,900 companies have been registered with the AIFC from 72 countries. Quality mark, and I addressed that earlier, this is not a recommendation, an endorsement of the quality of individuals, but it represents that they've gone through certain steps. There's a fast-track registration process for people who are recognized by an appropriate body in another in another regime, and there's operational ease. No need to establish a legal entity. We can accept individual practitioners, indeed people only in their personal capacity for the LSB, and a low level of fees at $150 per annum. Registration requirements require completion of an application form which contains the questions I might expect, and provision of documentation, which is either a copy of a practicing certificate or a letter of good standing from a recognized professional body, for example, the Law Society in the United Kingdom, or in the case of Kazakh lawyers who don't have a Kazakh or other certification from a recognized professional body, an eligible law degree will give them the ability to be registered. Legal Advisors applies through the office, admirably run by the team in the front row here. They and their team do the underlying due diligence and analysis and present to the LSB the applications and breakdown as to whether they're compliant. If they're not compliant, the applicant will be told that and why they're not compliant, and we may well be able, as the LSB, to say, we'll approve the registration subject to completion of any outstanding issues. And having gone through that process, very lucky, you get a certificate with a facsimile of my signature on it. The regime for the approval of legal services, I won't repeat in detail what's on the screen, but there's a whole series of individual rules, fees, recognized professional bodies, legal services code, and continuing practice development. The regime is now in effect, and each LSP, as I think I mentioned earlier, must employ at least one registered legal advisor. It is optional. There is no need to be an LSB member, LSB registered, in order to provide AIFC legal advice, and you can do that anywhere in the world, and it is not a requirement to appear for Chris's court or to participate in IAC dispute resolution. That is a different stream. We're hearing a lot, and these are my concluding comments, about the development of the AIFC, moving from this infrastructure, physical infrastructure, as we were discussing on a panel this morning, and the legal and regulatory regime, to a real business, which is providing a real service to companies wishing to invest or lend money into Kazakhstan, and companies within Kazakhstan wish to grow. That is what it's for. Also, the build-up within this fabulous building and center of a body of professional advisors and practitioners to give effect to these rules. So this growth, which is fundamental importance to the country and to this center in particular, requires professional advisors with good knowledge of the AIFC rules, regulations, and procedures, and they are continuing to evolve. There's been a number of issues of feedback over these 2 days, of issues which people have identified as requiring tweaking, and you're very lucky here that that can be easily done. There need to be people with experience, like my colleagues on the panel, who are able to give effect to these, and an innovative approach. It's an innovative center with innovative ideas. And cooperation by you as the legal community in developing these skills could be a source of mutual benefit. There is not the finances or the structure here to have the kind of subsidized educational programs as there may be in other jurisdictions. So if as a group, you as lawyers can get together, and we are all happy to do whatever we can to support that, to build up the level of expertise. And as successful lawyers practicing the AIFC, you are superb advocates, promoters of the AIFC. If you go out to your clients and say, we've done this fantastic deal, obviously respecting client confidentiality, and this is the place to do business, that's what it's all about.
Thank you very much indeed,
So thank
Simon. Chris, do you think you can manage to... Yeah. I now call on Chris Campbell-Holt, Registrar and Chief Executive of the AIFC Court and IAC. Chris, can you do justice to your subject in 7 minutes?
Absolutely not. I'm going to just give you concluding remarks. So I will keep to 5 to 7 minutes, and anybody who's expecting to leave this session as an expert on the AIFC Court or Arbitration Centre will be sadly disappointed with what I'm about to say. What I can recommend strongly is that you study very carefully, whether you're a lawyer or not a lawyer or whatever background you have, study the AIFC Court regulations, study the AIFC arbitration regulations. That will give you a useful picture of what it is the Court and Arbitration Centre can do from a lawyer's perspective. I want to start by saying, gosh, we've got times on there, I've just seen that. the clock's ticking. I want to start by saying what we are not. Now, it's a common misunderstanding, maybe it's a language issue, but I think it's more than that in some cases. We are not an arbitration court. We are a separate, independent, commercial law, civil law court. And we are a separate, independent, international arbitration centre. There is no such thing as an arbitration judgment, not here at the AIFC. It's an arbitration award, whether it's an interim award or it's a final award. And if it's a decision of the AIFC court, it's a judgment and or it's an order of the court. So let's be clear, there's an independent commercial court, there's an independent international arbitration centre. Are they competing? Nope, they're not. You often find that they will compete. We are providing a complementary, holistic, one-stop shop for international standard commercial dispute resolution for the whole of Kazakhstan and Eurasia through the AIFC Court and Arbitration Centre. In terms of using the court, one needs to look specifically at Regulation 26 and Regulation 27 of the AIFC Court regulations. In Regulation 26, you'll see the jurisdiction. Now, any lawyer or person bringing a claim to the court will immediately, if they know what they're doing, will look towards Regulation 26. Do I even have a claim? Should I even be here? And the court has already had a considerable case volume and often looking at the jurisdiction issue. Is this the right place to come? The court has exclusive jurisdiction for AIFC law. Everything you've heard about so far this afternoon is applicable in the court. And as a court, the AIFC court is the only court anywhere in the world. You cannot go to the national courts of Kazakhstan for an interpretation or application of the AIFC law. You can only come, if it's a court, to the AIFC court. But don't let anyone misunderstand that you cannot go to the arbitration centre for application of AIFC law. Of course you can. You bring the AIFC law to the arbitration centre, you bring the AIFC law to the AIFC court. I hope that's clear. And that's for mediation, arbitration, judicial mediation at the court, mediation by a judge, and your classic, which we all understand, I'm sure, litigation at the court. The court is not a tax court. Don't expect to be able to bring a Kazakhstan tax code legislation piece of dispute work to our court. Not going to happen. The Chief Justice, Lord Mance, and his predecessor, Lord Wolfe, who created the court more than 5 years ago, have made it very clear that is not the appropriate forum to come with English-speaking judges who are not Kazakh law experts to work their way through extremely complex tax code work. The place to go for that would be the national courts of Kazakhstan. Query whether it's possible to bring it with consent of parties and maybe the state to the arbitration centre, but that hasn't been tested, and we don't know for sure what the position would be on that. That said, the Chief Justice has made a position very clear that if there is a substantive dispute which has got jurisdiction at the AIFC court, and a tax element under the Kazakhstan tax code becomes a part, maybe it's a quantum issue relating to a tax payment, and that's a part of a dispute which has already been acknowledged by a judge as having jurisdiction at the AIFC court, then yes, the judge probably will. We don't know, it's not been tested, but probably will. That's the consensus of the judges so far out of case proceedings. They would consider that in the dispute. Does the court have precedent? Yes, it does. The court, of course, will consider its own judgments that it's giving, and it's now giving. It's given 64 judgments. Those are available free of charge in English, Russian, and Kazakh languages via the AIFC court website. We have about 20 other cases currently on the go at the moment, so watch this case. There'll be more judgments coming out very soon. Principles are being developed. The typical areas of the AIFC law, which is increasingly implied, and by the way, the AIFC court has jurisdiction to apply any law. It doesn't just have to be AIFC law. We expect it to be. We hope it will be. It increasingly is AIFC law, but it's often Kazakhstani law, or it's English law, or it could be German law. It could be any other law, as long as the parties agree in writing that's the law they want to apply in the case, and there's nothing in law prohibiting it. I'm running out of time, so very quickly, we are not a court for crime. We're not a court for administrative disputes, and I've said tax. We are a court for commercial and civil disputes, basically any type of contractual claim as provided by the AIFC law or any other law that's applicable in a case before the court and the arbitration centre. One principle which is key, which has come out, and this is a fundamental misunderstanding, which I completely understand, and that comes really from what's provided in Articles 4 and 13 of the AIFC Constitutional Statute 2015, and that is that where the AIFC law is the applicable law in a dispute at the court or the arbitration centre, particularly the court, if the law is not clear, if there are gaps in the law, that the automatic default position will be that the Kazakhstani law will fill those gaps. That is simply not true. Don't believe anybody who tells you that. It's not right. What the judges will do, and there's now a judgment to good effect on this, if I may have 30 more seconds, I'll be very grateful. What the judges have decided, a judge in a court, and the judgment is available on the website, Justice Tom Montague-Smith, KC, has decided, rightly, we all think in the court, and it wasn't appealed, that if the AIFC law is not entirely clear on a point of AIFC law, then the next place, logically, that the lawyer should be going with the judge is to use common law principle. Either from the English legal system or from any other common law system, or indeed from anywhere else. The judges will consider it, specifically though if it's from a common law system, because that's used as the background, if you like, for where we got to eventually with the AIFC law that we have in the form that it is. So that's a very important point, and only then as a very last resort, and it really is a very last resort, would a judge turn to Kazakhstani law to fill the gaps of the AIFC law. So that's practical application in action. Very quickly, if I may, enforcement, and this is my last point. We don't enforce through the Kazakh courts. We're friends with the Kazakh courts. We are absolutely independent. If you have an arbitration award, interim or final, at Mr. Krummel, our IEC chairman, who's in the audience today, at his arbitration centre, you come to the AIFC court for enforcement. You get a recognition and enforcement decision from a judge at the AIFC court. It can be done, has been done, as quickly as 60 minutes. 90 minutes, worst scenario, 24 hours. By a judge, done via video, it's already ahead of time. Done. Comes to me as the registrar and as the enforcement judge, goes to the judge, gives his decision, acknowledges it, and then straight away, execution order, out to the parties, out for enforcement. You go anywhere else, I'm not going to name competitor financial centres, but there's a few I'm aware of where it will take 3 or more months and will cost you $5,000. We're doing it in literally hours, and it's free. So it's extremely useful, I hope, and practical in terms of its application for you and your colleagues. The court enforces its own decisions by giving an execution order through me as the appointed enforcement judge, appointed under the regulations by the Chief Justice Lord Mance. It goes out under a special step-by-step enforcement procedure for enforcement anywhere within the entire territory of Kazakhstan. Not just Astana, not just Almaty, every single region, every bit of Kazakhstan is covered for this purpose. We have a special enforcement regime. It's been supported by the Ministry of Justice of Kazakhstan. There's a special escalation procedure. If things are not done perfectly and quickly, we can immediately get the minister on the phone, and that is genuine. We have him directly on the telephone, including the new Minister of Justice. We're always up to date to make sure it's always efficient and effective. And if enforcement internationally is required, we have arrangements in place specifically under Kiev Conventions, and we're getting increased recognition and support from the Supreme Courts and Ministries of Justice in, as I was saying this morning, in at least 8 other countries within close proximity to Kazakhstan. So in the round, the court is now being, and the arbitration centre are being used effectively by multiple parties, from not just in Kazakhstan and the AIFC, but all around the world. It's 23 countries of representative investors. Everything's been enforced, including, by the way, 8 cases against the state of Kazakhstan. The state has paid up absolutely everything as it currently stands. No problems. They go through the normal processes and no games, there's no tricks. It's done effectively, and we're monitoring and supervising it ourselves. And I hope that proves to be very attractive for you, as it has proven to be in more than 2,000 cases for many other investors. So thank you very much. I'll stop.
Well, thank you very much. That was a whistle-stop tour of a very big subject. Thank you very much indeed, Chris. Thank you all for attending. I'm sorry there hasn't been time for questions, but I hope you've all got something of usefulness out of this session, and I declare it closed. Thank you.